New framework on how to strike jurors for cause in Indiana. Hello, I am Jamison Allen. We are making this video to bring fellow trial attorneys up to speed on the new Indiana Supreme Court case law and the new framework on how to strike jurors for cause in Indiana. This video applies to all trials, civil and criminal, in all parties. Fellow Hoosier trial attorneys, the world of strikes for cause has changed. Thanks to a recent Indiana Supreme Court decision, Clark versus Matar, we now have a greater opportunity to force the trial court to strike a juror for cause and preserve our client's peremptory strikes. We are including a link to the decision below. Here are 8 suggestions of how to strike jurors for cause successfully. Suggestion number 1, read the jury rules. You might be surprised, but a lot of attorneys do not read the rules. We all need to read the rules, even when we think we know them. In Indiana, Jury Rule 5 and Jury Rule 17 are particularly important. Rule 5 enumerates many disqualifying factors. The court usually catches all of these, but in the event the court does not, these factors guarantee dismissing the juror. For example, a juror no longer being a resident of the county. Rule 17 is where we find almost all of the action on cause strikes. In particular, 17A4 and 17A8 are common battlegrounds. 17A4 strikes jurors who have formed an opinion on the outcome of a case that cannot be set aside to allow the juror to make an impartial decision. 17A8 strikes jurors who have a bias or prejudice against or for a party. Now, in criminal cases, 17B4 also requires a strike for cause if that juror's opinion is based on familiarity with the witness's testimony. Below, you'll find a link to the Indiana jury rules. Suggestion number 2, know the case law. Do not underestimate the power of persuasive precedent, especially if you can set up your questions to match the questions in the reported case. In Clark versus Matar, the Indiana Supreme Court said that jurors are biased against a party if they are unwilling to provide the legal relief that the party is seeking. The Supreme Court reversed and remanded the matter for a new trial because a reluctant juror was opposed to providing money damages in a civil case. The trial court denied our client's strike for cause, and our client was forced to use a peremptory strike to remove this unfit juror. Clark versus Matar applies to both civil and criminal cases. Jury selection is jury selection, and bias is bias. In fact, the dissent in Clark versus Matar explicitly worries about how the decision will play out in criminal trials, lamenting the possibility that witnesses in a criminal case will be forced to testify in 2 trials if the prosecution does not concede that cause exists, and the trial court wrongfully denies the defendant a strike for cause. Fellow Hoosier litigators, please read Clark versus Matar. The opinion is truly a gift to anyone who believes the fairness of trials is more important than efficiency. Suggestion number 3, get the jurors talking. If you follow the philosophy of using jury selection to try your case and indoctrinate the jurors, you are far less likely to have a sufficient case to establish cause. You can find a laundry list of seminars with strategies to get jurors talking. Some might work for you, while some others might not. Choose a strategy and rehearse your jury selection. The simplest advice I can give you is this: you will never waste time asking a juror about themselves. Not asking if they can follow the law, not jumping to a question about their view on which burden of proof is appropriate. Truly ask the jurors about themselves. Get them talking, listen to what they reveal, then transition to issues of bias. Suggestion number 4, get the magic words. Mere discomfort is not enough to establish cause in Indiana. In Clark versus Matar, the juror said he wanted no part of sitting on a jury, asked for a verdict of money damages. If that were all he said, we might not have convinced the Supreme Court to reverse and remand the case for a new trial. Additional questioning led the juror to say, "I can't sit on a jury who must consider monetary damages." Affirmative, definitive statements establishing bias are sometimes not easy to obtain, but they guarantee a strike for cause if the juror is not rehabilitated. If you cannot get the juror to say magic words on the issue, get as close as you can and then argue to the court that the words in the context collectively establish cause. After all, the court will later tell the jury that circumstantial evidence can be just as convincing as direct evidence. Get the juror to admit she has a tendency to give one of the parties a head start or is inclined to reject part of the law. Get the juror to admit that she sure would not want a juror like herself, because that juror would not be impartial. Suggestion number 5, use the truth to box in the juror. The Supreme Court's decision in Clark v. Matar specifically advises counsel in trial courts to attempt rehabilitation of the juror once bias is exposed. The opinion does not state the opposing party's counsel and just says counsel. Therefore, all trial counsel in Indiana now seem to have a duty to attempt rehabilitation. Regardless of duty, you want to clarify the juror's views. If you do not, opposing counsel will now have an uncontested shot to walk that juror back to a level of mere discomfort. Classic walking back questions are, now, you're a fair-minded person, aren't you? Now, you're saying that you can set that view aside and decide the case based on the evidence in the trial, right? If the evidence in this case showed you that you should give money damages, would you do it? Knowing that your views lean you one way, if the judge gives you instructions to follow the law, will you follow the law? With all the trappings of a court, the seriousness of the proceeding, and a judge staring down on them, how many people are seriously going to say, no, I will not follow the law? However, some jurors will stick with the truth and tell you that they are not the right jurors for this kind of case. You can make your opponent's walk-back questions meaningless if you do something like this. In our scenario, the issue was money damages. Thank you so much for being honest and sharing that with me. Now, I appreciate the reasons for your beliefs, and I'm not trying to be difficult, but the Indiana Supreme Court recently said, in these situations, I have a duty to clarify your beliefs. So the jurors in this case are going to get instructions from the judge, and those instructions will say that if they find for plaintiff, the jury must consider money damages. Now, are you saying that you're not the right juror for this kind of case because your beliefs essentially prevent you from following those instructions? If you get a reluctant, well, I'll try my best, you need to ask, would you be eager to interpret the evidence in a way that would allow you never even to reach the issue of money damages? Now, if that answer is yes, that juror should be struck for cause because that juror is inappropriately inclined for a defense verdict. Suggestion number 6, move the strike for cause on the record. Include each and every fact and argument that conceivably supports your strike for cause. If the juror rolled his eyes or did anything else with body language, state it. If the juror raised his voice, state it. Cite the jury rule, cite the case law, cite the questions and answers in the cases if they are close to what the judge just heard the juror say. If your strike for cause is denied and the matter is whispered at sidebar or in chambers, ask the judge to allow you to make a record immediately. Specifically request to do it before the jury selection panel is dismissed and the jury is sworn in. If the judge still refuses, request to do it at the earliest possible opportunity. Any delay in making a record can be used against you and imply you waive the issue for appeal. Any failure to state an alternative argument for your strike for cause can be considered a waiver of that argument. Know which juror you would have struck with your last peremptory strike if the judge had granted your cause strike. Know the reasons for wanting to use that peremptory strike on that juror. Put this information in the record. You have one chance to do it. Suggestion number 7, use all your peremptory strikes. If you do not use all of your peremptory strikes, you waive your ability to challenge the trial court's strike decision. Perhaps you have a strategy reason to hold on to one of your peremptory strikes now because you see how the strikes are playing out. But you need to know that you now have no chance for an appeal on the cause strike issue if you use anything less than all of your strikes. Suggestion number 8, give yourself a chance to succeed. What do I mean by that? Consider working the ref before the trial. You might want to file a pretrial brief that summarizes the case law on cause strikes if you think the judge will not be offended and advising him or her of the case law will grease the tracks for your argument. Request in the final pretrial conference that the judge conducts jury selection in a manner that allows cause strikes to occur outside the presence of the jury. In my experience, the best practice is having a recess for the jury pool when the time for striking arrives and keeping the jury pool out of the courtroom. With that practice, all the strikes can easily be on the record immediately. For judges who worry that granting strikes for cause just encourage more strikes for cause, explain that the judge can refrain from entertaining any cause strikes until the end and force all the jurors who might be removed for cause to wait with everyone else. With the cause strikes and the peremptory strikes occurring at the same time outside the presence of the jury, the jurors never know how they were removed or what statements work to get someone out of jury duty. Do not play the game where you argue that everyone who favors plaintiffs should be removed for cause, but everyone who favors defendants should only be removed with peremptories, or vice versa. You earn credibility with the court when you admit that someone who is just as biased in your favor should be removed for cause. With that credibility and your obvious knowledge about cause strikes, the judge will be more likely to rule in your favor on the close calls. Protect yourself from an appeal. Even if you disagree with my approach to earning credibility, you do not want to give your opponents an automatic appeal for a wrongful denial of a strike for cause. If you do not concede cause on a strike when it exists, you now might be trying the case twice. Moreover, you now have to win the case twice. Protect your client, protect your reputation. Concede cause when you see it. If you have any questions, or even better, suggestions, my contact information is below. Now get in that courtroom and have yourself a fair trial.